So anything else on your mind?
Liz.
Yeah.
This is kind of a procedural question. And it has to do with the big news break from yesterday regarding Manafort.
Yeah.
So
I
are
just
those...
lost a bet, by the way, I'll tell you in a second.
So the 10 mistrials verdicts, does that mean he's going to get tried again on those 10
It's up to the
counts?
prosecution.
Okay.
Prosecution has to decide whether to go forward. The prosecution will make that decision based on the whole range of factors, right? Did they achieve enough of their goals with the convictions they got? What do they think their chances are? If they can talk to some of the jurors and find out what the vote was, and they find out it was 11-1, or for conviction, or on the other hand, it was 6-6, or whatever. They'll take that into account. Now, the defense can also move to have for a directed motion of acquittal on those charges, but that's very rare. As a general matter, it's up to the prosecution. And the reason I say I lost a bet is because a friend of mine predicted that I would be asked this morning about yesterday's developments.
Sorry.
And I said, come on. And there you go. So
I apologize. I'll reimburse you.
don't worry about it.
Okay.
Friendly.
I feel bad now, though.
But yeah, there were some developments in criminal law, obviously, yesterday. Just a word to the wise, being on time is important. Like 3 of you who walked in late this morning, that really needs not to continue, okay? Okay. All right. We are finishing. First thing on the boards this morning is to finish actus reus, and that leads us to Martin versus State. What was Martin convicted of? What was Martin convicted of? You are. Is that what you're on the sequence chart?
I think so.
No, you're actually.
My row behind.
You're in the row behind. Yeah, just in the row behind. But in the seat you're in, you are. Edwardson. Someone's in that row who shouldn't be on the seating chart. It should be McCullough, Smith, then Edwardson, then Lane, then Lawson, Doninger, and Boyd.
Oh. Do you have that many seats?
I'm sorry?
Do you have that many seats? There's not that many seats.
There's 1, 2, 3, 4, 5, 6, 7. Oh, that's true. Very good. Very good. All right, Mr. Smith, after class, come up and we'll change your place on the seating chart.
Okay.
Got it. All right. Okay. Okay, Mr. Smith, what was he convicted of?
He was convicted of public intoxication on a public highway.
Being intoxicated on a public highway. And why was he on a public highway, or by what means was he on a public highway?
He was detained from his home and escorted over the highway by police officers.
Okay, so let me get this straight, because there's a disconnect for me here. Okay, he was in his house, and apparently
he was arrested.
Well, but apparently drunk.
Okay.
Right? Apparently drunk in his home. And for whatever reason, the police came to his home, found him drunk in his home.
Yep.
Now, if you were a police officer, other things unknown to us. I mean, maybe he was in his home menacing somebody, but let's say we don't know anything like that. He's in his home being drunk. If you were a police officer and for whatever reason you arrived on the scene, what would you do? What do you think you'd probably do?
Probably ask a few questions.
Anyone else? I have a pretty specific idea what I would do.
Probably just put him to bed.
I'd leave him the heck there. Right? Right? That's the place where he can probably do the least harm to the fewest people. Right? He's not again, assuming he's not doing anything in his home that's hurting anyone else who's also there. Like, okay, let's just not make this situation worse. Let's not compound this. Let's put him to bed. I like that, right? Put him to bed or whatever. But the police don't do that here. For whatever, maybe there are reasons unknown to us why they don't. I don't want to make assumptions about the police officers being overly aggressive or using bad judgments. So maybe there were some facts we don't know. But for whatever reasons, they bring him out. And now that they've brought him out, he is charged with being drunk in a public place, being intoxicated on a public place. Okay? And what's the question we have to ask ourselves in terms of the validity of this conviction?
Was it a voluntary act?
Or flipping the phrasing of that, does the fact that he was there involuntarily make a difference? Right? Right. Is a voluntary act required, or does his being there involuntarily make a difference in the validity of this conviction? Okay? I want to start where we will start most of the time, with the language of the statute. And what I need now, and it might be Mr. Smith, I don't know, I need somebody who is willing to stand up and proclaim themselves to be a textualist. Somebody who believes that courts, the job of courts, is to apply the language of the statute. They shouldn't go beyond the language of the statute, or if it's a constitutional case, the language of the Constitution, and that the text is what matters. Who's going to be our resident textualist? Mr. Smith is not raising his hand, but Mr. Webb is. Right?
Yeah.
I should warn you, Mr. Webb, that that once that person each year in this class is identified, it is like a mark on you.
I don't want to do it.
Too late. But we have fun with it. We have fun with it because one of the things that sort of is going to be like a sort of a running sub-theme is the relationship between courts and legislatures. How do courts deal with statutes that are either ambiguous or can be interpreted different ways? And so we need somebody who's gonna sort of represent for us the idea that courts should be faithful to the text. So, Mr. Webb, what does the text of the statute say here?
It says just that he is drunk. Any person while intoxicated or drunk appears in any public place where one or more persons are present and manifests drug condition by boisterous or indecent conduct or loud appropriate discourse shall convict people.
And what's missing for our purposes from that statutory language?
Well, it just says any person who is there, not any person who places themselves there or is somehow put themselves there. Yeah.
Good. There's nothing in the language of the statute that says a voluntary appearance in public while drunk is required by the statute. So if a court, a judge, is going to say, look, my job is to apply the language of the law, and if the law is stupid, or if the law has bad consequences, or if the law doesn't fit the changing times, right? Maybe this law was written 50 years ago, then our job is to tell the legislature to get with it, change the law. We live in a democratic system, and laws can be changed, and the agent of that change is the legislature. So the outcome here, Mr. Smith, is his conviction is affirmed because his claim that, hey, I didn't voluntarily go out on the public highway doesn't matter to this statute, doesn't matter to this, to whether he's guilty, right? No? I'm speechless.
Me too.
Do you really what?
Me too.
Do you think I'm really speechless?
No.
Yeah, you should. What does the court say? Why does the court depart from the plain language of this statute?
Because they, in their holding, they have a voluntary appearance as presupposed.
Very good. A voluntary emphasis on this word, appearance. Oops. It's not in there, it's not in the language, but the legislature must have simply assumed that it would be required. That once a defendant was actually in the dock, in court, being tried, that that would be part and parcel of the elements of conviction. Okay? Why? Why does the court say that this is going to be required? That, in other words, since in this case he was carried out into the street, that the conviction cannot stand, must be reversed.
They say that an accusation of drunkenness in a public place cannot be established by proof that the accused, while in an intoxicated condition, was involuntary.
Okay, but why? Why would the law, as courts are actually enforcing it, have this as an element that's required? Why? Why would, if you were a judge and you're going to depart from Mr. Webb's text, what would be your justification for doing it?
Forcibly, like, bringing them there is not committing the act for them to come out. So,
I'm sorry?
forcibly bringing them to where they're going and kind of committing the act for them, committing the criminal act.
And
That's kind of like framing them or taking away their chance, their choice to put themselves in that position.
so what? If I came back, if you made that argument to me as the lawyer for the defendant, for Martin, right? And I was the judge, and I just said, okay, so what? Why should I care about that? Why should I care about that in a way that causes me to either dismiss the charges if I'm the trial judge, or reverse his conviction if it goes up on appeal? So how do you answer the so what question? Yes, it was not his act, but the statute says he only has to be in the public place.
Would be intent.
I'm sorry?
Intent.
We don't want to go over to intent yet. We'll do that later in the class.
Wouldn't that be entrapment of some sort?
Okay. What does the idea of entrapment? Why do we not allow entrapment?
Well, that's going back. I was going to say it's really hard to create a general deterrence for involuntary.
It's hard to create a deterrent for an involuntary act. I like the way you used our purposes of punishment there. But let's get even more basic than that. How many of you would be comfortable with a criminal law that you would all be subject to, where we'd all subject to this, so the power of the state can be brought to bear against us in circumstances in which the thing that we are said to have done, somebody else compelled us to do? Compelled us, in this case, a police officer, by bringing us out into the street. How many hands? Show of hands. How many people are comfortable with that? Zero. So what does that tell you about why we might not want to do that?
Common sense is just wrong.
It's just wrong. Fairness. Fairness is unjust to convict somebody for something he or she didn't do. Right? If somebody actually didn't, let's say, bribe somebody who had an affair with the president, if somebody didn't do that, it would be unfair to convict them of it. So sometimes what we mean by they didn't do it is somebody else did it, or it wasn't actually done, no one did it. But as a fundamental principle of fairness in a criminal justice system, that you punish the person who did it. So here, who did it, Mr. Smith?
The police officer.
The police officer. So the Voluntary Act requirement reflects a simple principle of justice. A simple principle of justice. And Martin, therefore, has a good right to complain. Okay? All right. Now, Martin and Newton, the case before it, dealt with situations in which an external act that would otherwise have been criminal was said to be not criminal, not punishable, because it wasn't the act of the defendant. It wasn't the act of the defendant due to voluntariness. I want to look at the flip side for a minute. Sometimes an external act, even when accompanied by criminal intent, is not punished. And I want to give you two examples, one at a time, to explore that sort of converse situation, which seems very puzzling. And for the first one, I need someone, if we have anyone in here, who has served in the military. No one? All right.
My
Wow.
dad's a 10-year Navy veteran. Does that count?
I'm sorry?
I have a father who served in the Navy for 10 years. Does that count?
No. But we'll take anyone. Since we don't have somebody served in the military, that's the first time that's happened in 23 years that I've had no veterans in the section. But wow, everything, first time for everything. So anyone, so you're gonna have to take this blind, and that's Mr. Healy.
Young.
Mr. Young. Okay, Mr. Young. Here's the hypo. You ready? A soldier during battle shoots. So you have an act, it's a voluntary act, shoots with intent to kill his commanding officer. Okay? And he believes he's doing so, but instead kills the enemy. Okay? What is likely to happen to that soldier?
I'd say it's likely he's reprimanded in some way, but there's...
Really? What happens usually when a soldier in battle kills the enemy?
Congratulated.
Maybe gets a medal, right? Depending on the circumstances, right? Soldier in battle kills the enemy. Okay? Probably going to be no negative consequences and potentially some positive consequences. Okay? Why is that?
Because he was never able to carry out his intent of actually shooting his commander in the act that actually happened.
And why would the criminal law not be in a position to punish that?
I think it's similar.
Despite, let's say, I just told you that his intent in his head was, oh, I'm gonna kill that SOB commanding officer who I've always hated from day one, right? Why wouldn't the criminal law be able to punish that?
It makes me think of the case where he had the intent to sell and distribute alcohol, but since he never actually carried out the act, you can't.
But here he did act. Here, unlike that case, that's Newton, right? Unlike that case, here we have the affirmative act. He takes the shot. He takes the shot, right? That's not the shot, that kind of shot. Right? He takes the shot. What's different?
There's no proof of the act of killing the commanding officer or evidence that he was.
Well, why not attempted murder then? There's an act of trying. Why can't he be charged with attempt? Why wouldn't the criminal law do that?
Well, if you can't prove the intent, the act wasn't criminal.
Because of the problem of proof.
Yeah.
Right? Prosecutors have to worry about what can I prove? What can I prove? And as far as you can tell, unless he said to his bunkmate, I'm going to take my shot today. I can't take this guy anymore. I'm going to take him out. Unless you have something like that, which is probably unlikely unless this guy's an idiot. Okay, second one. Okay? Who wants to take the second one before you even know what it is? Miss, I can't even read your writing. I cannot read your writing, literally. Cervera. Okay? Here it is. You ready? A man has sexual intercourse with a woman who is over the age of consent. Okay? But believing she is underage. So we have the act, we have the act of committing sexual intercourse, just like the act of shooting the commanding officer, and we have the intent to have sex with someone who's underage. the illegal act, right? Prosecution, or they just had sex.
Well, there might not be the evidence that he believed that she was underage. All you have is the actual fact.
Same problem. Here's my question on both hypotheticals. What separates the soldier who does kill his commanding officer from the one who kills the enemy? What separates the guy who has sex with a woman who is of age versus the one who actually has sex with the one who is underage as they both intended? What separates them out?
There's no evidence of intent.
Okay, that's one thing that separates them out. What else separates them out?
There's an actual act.
There's an actual act in both cases, right? There's an act of intercourse with underage and with a woman who's of age. There's an act of shooting in both cases. So there's an act in both cases. What else?
There are criminal acts that can't be proved.
There's that problem of proof, yeah. What else?
And chance.
Random chance. Or to put it another way, dumb luck. Dumb luck. And I want to emphasize for you, and we will come back to this again, at least for some frequency, the idea, although we don't like to admit this, that dumb luck plays a big part in the criminal justice system. Right? In terms of the outcome of your actions and what you can prove. Right? Simple dumb luck. Both of those soldiers had this one of whom commits the act of shooting a commanding officer on the battlefield. That person's going away to Leavenworth for a very, very long time. The other one had the exact same intent, just happened to be a worse shot, or was, something got in the way. The enemy happened to be in the line of fire right at the last moment. Dumb luck. That was luck. Nothing was in the soldier's control, but dumb luck. So when you make consequences, what was the end result meaningful in the criminal law? You are letting dumb luck play a part. And I don't mean that as a criticism of our criminal justice system, because a lot of times people hear that and say, oh, he's saying there's no rationality to it, there's no justice to it. I am telling you it is an inevitable part, and we should not pretend otherwise, without necessarily meaning that as a criticism. Do I see, is that a question?
Yeah, what if we flip that, like felony murder in a lot of states, if you're doing something dangerous and illegal and a felony, like,
Armed robbery, let's say.
armed robbery, and you happen to accidentally kill someone in the process, then it's like on the driveway or something, you just hit someone on a bicycle. Instead of that being like voluntary manslaughter or involuntary manslaughter, like most states will bump that up to second-degree murder.
Well, felony murder, I think there are better examples in felony murder of why dumb luck is felony murder is another example of dumb luck. But I want to, before I talk about that, felony murder is a vanishing offense. It's really not true that most states use it anymore. Kentucky does not have felony murder anymore. We'll get to that when we get to homicide. But here's an example. Under the felony murder rule, if you committing an armed robbery and your accomplice kills the clerk at the store, you can be guilty of murder, right? That's like the paradigm example of dumb luck. Let's say you even talked about it beforehand. We're not going to shoot the clerk. I don't want to have, a potential murder rap hanging over me, right? If push comes to shove and he just says no, I'm not going to give you the contents of this cash register. He's called our bluff. We'll just leave. Maybe we'll pistol whip him to try to get the proceeds, but we're not going to kill anyone. But your accomplice gets his blood up and says, he's saying no to me, I'm going to shoot. That, dumb luck. So felony murder, I think clearly, especially some manifestations of it, reflects this idea as well. I think that's right. So, yeah. And as I said, outcome, the main way in which a dumb luck plays a role is because outcomes matter. Whether you do harm by your actions when you try to do harm affects whether you can be prosecuted and what you can be prosecuted for, as we'll see. Okay? So I wanted to pause there to sort of inject that into your mindset, your consciousness, as we go through the rest of the semester. Okay? The last thing I want to say before we move on to Grant is this. Martin illustrates the overlap that can exist between act and mental state. The problem with the conviction here, but what the court says is the reason it has to be overturned, is that Martin did not act in the way prohibited by the statute. He didn't go onto the public highway. You could also conceptualize this as saying Martin didn't intend to go on the public highway. It was the police officer's intent to bring him there, right? And you need to keep these distinct. It's really important that you keep these distinct. And the way to do it is by asking this question. By asking this question. Did the person, him or herself, do the thing the statute says is punishable? Ask that question first, with no focus on or even attention to what the person's intention was. Just, did the person do it? Did the person, the defendant, him or herself, actually do the thing the statute says is punishable? Don't ask, did they intend? And also don't ask, did the thing occur? Right? Because if you ask, did it occur? Well, yeah, Martin was on the public highway, and then you're inevitably, or at least probably, going to go over into, well, did he intend for that thing to occur? Simply ask, did the person do the thing? Did the person do the thing? Being on the highway is not an act, it's a circumstance. Did he go on the highway? That's his act, or in this case, the lack of it. Okay? Everyone there with me? Yeah.
Okay, so with this, what if, like, same facts, but instead he was involuntarily intoxicated and then went on the highway by himself or whatever during the rest, but
He was involuntarily
but he was
intoxicated. Somebody spiked his cider.
Yes, and so the same thing happened. He got arrested. Say he himself walked onto the highway, but then acted that way.
What do you think the answer would be?
I would think that he wouldn't be ordinance because he was involuntary. I think that
Now, there are special rules about involuntary intoxication. But putting that aside, for what we've studied so far, you're exactly right.
So that involuntary applies to basically the three acts that are in that statute: getting drunk, being in public, and acting like a fool.
And acting like a fool. That's right. I think that's right. Now, you could, if I were a prosecutor, I would try to make the opposite argument, that being intoxicated is a status, not an act. And so the statute doesn't require that as an act. But I think that's a losing argument. Okay? Okay? Anything else? Okay. Speaking of intoxication.
Sorry, before we move on, I just have a quick question.
Yeah.
Why is public intoxication criminal, not civil?
Well, the short answer is because our legislatures have decided that it crosses that line into, I mean, civil liability is when my actions harm you, and the state has decided by its tort law to make that action I've done to you, that harmful action, compensable. So the idea of tort law is to compensate you for harm I did to you for some sort of wrongful conduct. The criminal law tries to punish harms against the public interest, and it's the state that brings the case and our main interest is punitive, not compensatory. So we decided, rightly or wrongly, that public intoxication leads to social harms that deserve punishment, that deserve that the state's sanction, regardless of whether my public drunkenness does specific harm to you. Now, if while I'm publicly drunk, I smash the window of your business, that's the fact that I might also be culpable under the criminal law for public intoxication doesn't preclude you from suing me for that tort, for the damage to your business. Maybe you have, the actual repair costs. Maybe you have to close up, so you lost profits for a couple of days while it was repaired. So you can sue me as well. It's not either or. Sometimes the same conduct can lead to both criminal and civil liability. We might decide as a society that we only want to make public intoxication a civil matter, and that it would only be the subject of when it results in harms, the person who's harmed can sue. We have decided otherwise, because we think public intoxication is so likely to yield harms to public safety, to public peace and quiet, that we're going to punish it. That may be a bad decision. We want the entire world to be like Bardstown Road on a Saturday night.
So criminal law is always punitive, but civil law sometimes is or never?
Well, that would be the easy answer, and I wish I could say that that's the answer. But the fact is, in torts, we sometimes have punitive damages given in order to provide a disincentive to harmful, bad behavior. So there's a punitive side to civil law. And in the criminal law, it has regulatory reasons behind it as well. We want to provide a disincentive for harmful behavior that is not simply punitive. But so there's blurring of those lines. But if you want a basic distinction and then sort of recognize that the purposes can overlap, that's the answer. Okay? All right. Now, that leads us to Grant. And Grant, especially coming hard on the heels of Martin, sort of establishes another running theme or thread that we're going to see throughout the semester, and that is that, boy, alcohol plays a big part in a lot of these cases, and people acting the fool. So what happened in December of 1974 at the Watering Place in Lincoln, Illinois?
Mr. Grant was having a drink at a local tavern.
A drink or more. Or more, yes.
When another patron had an altercation with the tavern owner, the police was called on the patron, and while he was being taken outside by the police, a crowd followed them outside.
And the crowd was rooting for the police, right? No.
Oh my God.
The patron. And then the defendant, Mr. Grant, came out of the crowd and struck an officer twice.
No, come on. We need more color than that. This is Grant is our hero in this case. Grant is like he's like
He's like, I'm gonna
give me some sense of how this unfolded. Right, this crowd is cheering on the patron who's resisting arrest, and Grant rises to his rescue. Right?
Yes.
Yeah, he
heroically leaps out of the crowd and strikes the officer.
Yeah, using a parking meter for leverage.
I'm sorry?
He says here he used a parking meter for leverage. Like he leaped off of it and then
All right, Ms. Harper, I'm going to say this now. Wait till you're called on.
Sorry.
Because that's the word of the day. And you'll get it, but restraint, okay?
Sorry.
Who has the envelope? Would I give the envelope to? Oh, this morning. Parking meter, okay? So he leaps from the crowd, hoists himself, probably whipsaw over the parking meter and assaults the officer, right?
Yeah.
This guy's like, the crowd must have gone crazy, right? Okay? And so, and he strikes the police officer in the face. What then happens?
He's restrained by another police officer and taken to a cell, the local jail. Once at the jail, about an hour passes, and he has a seizure and is taken to the hospital.
Now the sequence here is he's at the bar, he assaults the police officer, he gets arrested, he's in the cell, and then he has the seizure, or at least that seems to be the sequence, right? And he's taken to a hospital, and he's there for 10 days. This is some seizure. Okay, this is some seizure. Now, why would his post-arrest seizure, according to Grant, be relevant?
It's relevant.
Why does he say it's relevant? Because, I mean, why? It seems like, hey, conduct that occurs after you're arrested wouldn't be much of a defense to conduct that occurred before you were arrested. Why does he argue it is relevant?
It's relevant in proving his the medical condition he has some form of epilepsy.
And so he has a history, right? He has a history of psychomotor epilepsy. And what has happened? If you're his defense lawyer, how do you use this history to try to build your defense for him?
You argue that he was having an episode and was not lucid during this time, and therefore he cannot be held liable for involuntary conduct.
And he has had other times in the past where he's his condition, his epilepsy, has caused him to engage in violent attacks on other persons while he's not conscious of what he's doing, right? Okay, and so he says the defense is he went blank even before the seizure. That is part of a whole sequence, and that just because some of the manifestations of the seizure occurred in the prison cell doesn't necessarily mean that he was conscious of what he was doing at the bar and outside the bar, okay? He says he didn't remember anything, including what happened with the police officer, until he awoke 3 days later. And what support does he offer for this theory of the circumstances?
He offers an expert.
Excellent, right? He has an expert witness who says that he had a seizure which prevented his conscious mind from controlling his actions. Okay, now I need a prosecutor. This sounds like a pretty plausible theory, a pretty at least decent idea. All right, Ms. Cull, right? Ms. Cull, what does the prosecution say about this?
The prosecution looks to evidence of past arrests where they say that, his strength is so great whenever he is having these seizures, and that it normally takes more men to hold him, and they use that as evidence because the officer could do it on himself in this case. So they use that as evidence that he wasn't blacked out during this altercation.
And one of the officers, Yarcho, says he was alert and not confused when he was arrested, right? So what does this call, from what we discussed the other day, what does this show, or what does this illustrate? This dispute between one version of how he was affected, what his state was, what his consciousness was, when the seizure really kicked in. What does that illustrate for you?
An issue with the facts.
It's an issue with the facts. Remember, we talked about that the other day, that factual disputes are for the jury to decide. The jury wasn't required to buy the expert, Dr. Luden's version or testimony, because it was based on what Grant said he was experiencing. And if the jury thought, you know what, there are facts that go the other way, we'll look at it in that light, in the light the prosecution presented it to us. And we believe that he was lucid, that the seizure came later. They didn't have to find that way. They could have found for the defense, but it was a permissible way, okay? So the jury wasn't required to buy the defense version of the facts, but what still happens nevertheless? We see it again on this appeal.
Was improper instructions that were given to the jury, and so they were instructed to treat the defendant's situation more like a mental illness, I think more like insanity, and there should have been a different set of instructions given because it shouldn't be treated like that.
Right. The court, remember we talked about this distinction between act and mental state. The trial court's instruction to the jury talked about what amounted to the insanity defense. It told the jury that Grant could be acquitted if he lacked the substantial capacity to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law. That's the insanity defense, right? That's not the issue he's really presenting. He's saying, did I even commit a voluntary act? And if you're unconscious, you can't commit a voluntary act. Right? If there's a lack of consciousness, you can't commit a voluntary act. So it's not like being dragged out onto the street. It's a different reason why the act wouldn't be voluntary, but the jury had to be at least told this was something to consider. Right? If he didn't commit the act, then he would be or should be acquitted. Again, they wouldn't have to find that, but they have to be given the option. Okay? So on remand, Mr. Williams, what does the court say about how the jury should look at this case?
The court gives them new instructions that they have the ability to determine whether he was in an automative state, which is, I think, how they define that psychomotor seizure. That they have the ability to determine whether or not he was in an automative state and whether he was in control of his actions or not. That's a factual question.
So does he, if they find that he was had been subject to a seizure and that the seizure had already kicked in, so to speak, does that mean the defense will win? Or does the court give a but to that?
I remember that if they found he was sane, then it was, the verdict was okay.
There's that.
Right. I think that is a defense, is what they said.
Mr. Cannon?
They mentioned that if he had any reason to believe that, like, the whiskey could have contributed to his condition, like if he had any prior knowledge, maybe then it wouldn't, how did they word that? There is no requirement that every act preceding the actual commission of the offense be voluntary. So in other words,
the seizure may be involuntary, but if you had knowledge that you had some kind of trigger that would lead to your seizures, and you engaged in it anyway, then all bets are off for the defense. So maybe that's not true, but the court wants to note it to say that's a theory available to the prosecution, right? So if voluntary behavior that triggers the seizure, then your defense of involuntariness can be stripped away. Hence, there are certainly some triggers for seizures. Okay. Now, I'm going to tell you that I am epileptic. I've had 2 major seizures in my life, and I don't have any particular triggers that I'm aware of, so I would be fine on that score. But every state has rules that prohibit people who have uncontrolled seizures from driving. Okay? So if you make the voluntary decision to drive while your seizures are in an uncontrolled state, then you don't get the benefit of the involuntary act doctrine either, because you made the voluntary decision to violate the law and drive at a time when you are subject to seizures. For example, in Kentucky, you have to be seizure-free for 3 months to have your seizures deemed to be well controlled. Okay, I haven't had one in 13 years, so mine are very well controlled. Okay, but during the time immediately after each of my seizures, I did not drive. I had really good friends who got me around, but I wouldn't drive because I thought it was really a bad idea, and I was scared I would kill somebody. but also because I knew that this was true. Okay? So it wasn't about triggers in that situation, but effects. So if you take the voluntary act of driving while susceptible to uncontrolled seizures, right? They haven't got your medication fixed yet, they haven't found the right combination of medications, then you better not drive. Same idea. So all of this gets at the basic principle that, yes, there's this idea of involuntary acts when you're not conscious in an automative state, but there are some problems with that which will make it inapplicable in the circumstances I've described.
So going back to the Martin case, if he was involuntarily placed on the highway, but what about the behavior, like we don't know about this, but what about the behavior that first of all led to the police being called, or led to him being arrested? So what if those were voluntary, which led to the involuntary behavior? Like what's the...
If I were a prosecutor, I would try to argue something like, Martin, should have known, and it is reasonable for the law to hold him culpable for acts that, even though they were indirect, it was inevitable, it was natural and inevitable that they would lead the police to seize him, to drag him out onto the highway, that he would be arrested. I think the answer to that is, I think the best answer to that is, if there are those actions, then prosecute him for those, right? Instead of for public drunkenness, right? What are the kinds of things he would have done that would have made it an inevitable consequence that the police would arrest him, right? He was creating a public disturbance. Let's say because he was drunk, or at least partially related to his being drunk, he was, playing music really loud in violation of the city's noise ordinance. Well, prosecute him for that. Or, much more serious, but certainly plausible, is that he was committing domestic violence, perhaps related to his drunkenness, perhaps when he's sober, it maybe makes no difference, but he's committing domestic violence, okay? Prosecute him for that. Don't add on, look, now we've got a gotcha, because you caused us to drag you out into the public street, when the one thing he didn't do was be voluntarily drunk outside. So it's hard to imagine sort of that sort of narrow class of actions that would both leave the police and the state unable to prosecute him for anything else, and yet make him responsible for them bringing him out onto the street. Okay? Okay. All right, I want to ask a few last actus reus questions, and they require you to have your KRS excerpts available. So either pull those up on your computer, or if you printed them out, pull those up. Take a second to do that. Ready? Okay, first one, I'm going to ask you about several provisions of the KRS, and I'm going to ask you, what is the actus reus in those provisions? Okay, so I want you to get used to the idea of being able to immediately say, aha, that's the actus reus, I can spot that without batting an eye. Okay, the first one that I want to ask you about is section 507.030. KRS 507.030, manslaughter in the first degree. What is the actus reus of 507.030? causes the death of such person or a third person. Okay, and following up, 507.050, reckless homicide.
With recklessness, he causes the death of another person.
Causes the death of another, what'd you say?
With recklessness, causes.
What's recklessness in that sentence?
I guess that would be the mens rea.
That would be the mens rea. Causes the death of another person. What can you say about the actus reus of 507, 030, and 050? They're seen pretty much the same. What does that tell you? If the actus reus of two statutory offenses is the same, what must therefore be true?
The mens rea separates them.
Exactly. The mens rea is different. Okay? Once you see this, you know you better look to the mens rea, and you're going to see that it's different. Okay? For this one, it's recklessness. For manslaughter, it's not.
I have a question about language. On the second one, so you wrote on board of another person, but in the statute it says with an unborn child. Like, I feel like there's, with the law, is an unborn child a person? And at what point does an unborn child become a person?
I am so going to duck that. That, you know, as obviously you're all aware, the controversy, the fight, the disagreements in our society over the question of abortion and are heated and passionate, and in many legislatures, including Kentucky, they have passed statutes that in some way seek to recognize the status of a fetus as a human being in order to have that effect on abortion politics, making no statements about any judgment on that, okay? This is an example of that we will characterize the unborn as a human life subject to the protections of the reckless homicide statute, etc. I want to put that to one side because I don't want our understanding of something like actus reus to be clouded or affected by that particular, I think, separate question. Okay? If any of you want to talk about this in greater length and sort of probe it, I'll be happy to chat with you in my office. But I don't want to take class time and have us get derailed into a discussion of either the politics or the morality, etc., of the law as it relates to abortion. Okay, it's just maybe that's a bad call on my part, but I think we're better served that way for now, at least. Okay, my next one. Take a look, someone, and tell me the actus reus of 510.040. 510.040, which is rape in the first degree. What's the actus reus there? Ms. Fields.
Engages in sexual intercourse with another person without forcible compulsion.
Yeah.
Or engages in sexual intercourse with another person who is incapable of consent.
Good. That's your actus reus. Nothing there about the mental state with which the person acts. Okay? That's your actus reus. Identified it exactly right. And there are alternative acts there, both of which constitute the crime, or either of which could constitute the crime. You don't need both. Now I want you to turn to 510.110. 510.110, sexual abuse in the first degree. What's the actus reus there?
When he or she subjects another person to sexual conduct by forcible compulsion, or
So how do these statutes or these sections of 510, 040 and 110, how did they differ?
It went from sexual conduct to sexual contact.
What does 040 say?
Sorry.
Intercourse?
It says sexual intercourse.
Okay.
And 110 doesn't define the act as being intercourse that the person is subjected to without their consent or when they're incapable of consent, but sexual contact. And if you look elsewhere in 510, you'll see how the statute defines sexual contact, but it's different from sexual intercourse, right? It's some sort of intimate behavior that does not involve intercourse. So there you can see the two statutes differ in the act they proscribe, in the act, right? So there the difference is in the actus reus, right? So this is something I want you to get comfortable with, expert at, being able to both identify what the actus reus is, which part of the statute is the actus reus, and then how it might differ from other aspects of the statute's fees.
Do some, I guess, I'm trying to word it. Some crimes not have a mens res?
We will talk about that in just a few minutes.
Okay.
Paul?
Is it kind of like can intercourse be counted as conduct, but not all conduct is intercourse?
Go earlier in 510.010 and read me the definition of sexual contact. The definitional section, so it defines all of the various terms of the section, right?
So sexual intercourse means any act of sexual gratification involving the sex organs of one person by the mouth or anus or of another.
And which one is that?
That's 010.
Which definition is that?
That is right.
That's
The intercourse.
That's intercourse. And what's the definition for sexual conduct or sexual contact?
Any touching of the sexual or other intimate parts of the person done for the purpose of gratifying sexual desire by the party.
So how would you look at that?
I mean, it could.
Because intercourse involves touching, right?
Yeah.
So
Could you get charged for both?
you can be charged with both. A prosecutor can charge you with both, but you would only be punished if the jury would convict you of both. You are only punished for and sentenced for the most serious crime, if one is what is called a lesser included offense of the other. And in circumstances in which the contact happens to involve intercourse, obviously the contact would be a lesser included offense of the intercourse, of the forcible intercourse. Okay? So the prosecution might charge you because maybe they are not certain they're going to be able to convince the jury intercourse occurred, but touching definitely occurred. So you charge in the alternative. You hope to get the more serious one, but if you don't, you have the other one in reserve. Okay? But if both come back as convictions, then only one. Okay? We will discuss all of this in much greater detail. Okay? Anything else about actus reus? Before we move on to mens rea. Okay. Mens rea is simply whatever mental state is required for the act to be deemed criminal. We have our act. We're assuming we've got that in resolve, right? Whatever mental state is required by the particular statute, and there are numerous ones that we will discuss, okay? And the idea of requiring a mental state reflects the idea, if it's on page 199, that we should punish conduct, bad conduct. We should punish it only when it's accompanied by bad thoughts, if we're going to require a mental state. Right? It's sort of
converse of the idea that we shouldn't punish only bad thoughts. There should be an act, but the act alone is not enough. Sorry.
Just for clarification purposes, when we talk about mens rea, we're not taking into consideration like actual mental like health conditions or like possible defenses of insanity, right? We're just talking about like what the thoughts were at the time.
We're talking about a specific list of possible mindsets that the person might have had. The person might have acted with intent. The person might have acted with knowledge. The person might have acted recklessly. We're talking about what was the accompanying mindset that went with the behavior, period. Okay? Now, there are some circumstances in which we may punish conduct without a mental state, without a mens rea. Those are situations of strict liability. Okay? And the question is, A, did the legislature intend to do that? And is it consistent with fundamental principles of due process to do that? And we will address all of those questions. Okay, so that's part of what we're going to talk about, is the relationship between the existence of a mental state requirement and punishment. Then we will look at the different culpable mental states, some of which I just related to Ms. Harper. Knowledge, purpose, reckless, negligent. Right? These are possible mental states. So we'll look at the different mental states from the Model Penal Code that define crimes, or at least the mental state, the mens rea part of crimes, and the rules that the statutes use. And then we will compare these to their Kentucky counterparts. And then we will look at the relationship between the mental elements of a crime and the proposition or the situation in which the defendant is mistaken about some elements of the crime. Right? The defendant thought they were shooting their commanding officer. The defendant thought the circumstances were such that they were committing a crime, but maybe they lacked the elements because of that mistake. And so what do we do about mistakes when it comes to mens rea? Okay? I thought I was entitled to all that money in the safe at the bank. And so I didn't think I was committing a crime when I took it out of the safe, for example. Okay? So we'll look at different kinds of mistakes and how the law treats them. And that's sort of an outline of where we're going to go, and we'll begin that with People against Dillard. What was Dillard convicted of doing?
Carrying a loaded firearm in public.
And that's Ms. Walls, right? Mm-hmm. Ms. Walls, convicted of carrying a loaded firearm in a public place. And what kind of an offense is that? What level of offense is that?
A misdemeanor.
That's just a little misdemeanor under California's penal code. But still, nobody wants any criminal conviction on their record. And what is the legal issue that the California Appellate Court is dealing with when Dillard challenges his conviction?
Whether the knowledge or the intent that the firearm, whether the knowledge that the firearm is loaded is an element of the misdemeanor.
Because his claim is, I didn't know it was loaded. Right? There's one of our mental states that we're going to deal with time and again is knowledge. Right? Did he know? Right? If it's not an element of the offense, if knowledge is not an element of the offense, then the statute permits Dillard to be convicted, even if the prosecution cannot and did not prove that Dillard knew that he was doing the thing the statute prohibits, i.e. having a loaded gun, much less that he intended to violate it, or much less that he even knew that it was illegal. Right? And by the way, these are different things. I can intend to do something that a statute prohibits without even knowing there's a law about it. Right? Let's say I have no idea. I go to California, I have no idea that they have a law about possession of a loaded gun. But I know I have a loaded gun. I don't intend to do anything with it. I want it for self-defense. I know I have a loaded gun. So that's knowledge of doing the thing the law prohibits. That's one kind of knowledge. The other kind of knowledge would be, I actually affirmatively intend to violate the law, or I have knowledge of the law, and so I have knowledge I'm violating it. Okay? generally knowledge requirements require only the first kind of knowledge. Knowledge that you're doing the thing the law prohibits. You don't have to know about the law itself. And that the reason for that is the old axiom, ignorance of the law is no excuse. And we will talk about this more later. Okay? So we're talking here about knowledge about of the thing the law prohibits. Knowledge that the gun was loaded. Okay? So what happened? What happened that led to this prosecution and conviction?
So Dillard goes to his stepfather's house to pick up this gun. He's got it in the case. He says he gets on his bike, and that's when he's seen by the police officer because he's got this big rifle case on his back. He claims that he didn't know that the gun was loaded.
And by the way, when Officer Torres stops him, he complies with his request. Right. Is completely cooperative. He places the rifle case on the ground, steps away. Right? There's no confrontation here.
Right.
So what happens when Torres opens the case?
So he's got like one, I don't know a lot about guns, but he's got one in the chamber. There are several rounds like loose in the bag. And then of course he gets cited for the misdemeanor.
Right. And he says, oh, okay, this is my rifle. No dispute about that. And as you said, he said he picked it up from his stepfather's house like several hours before he was stopped.
Right.
And he says he hadn't opened it in the meantime.
Right, and that it was like the normal practice for a stepfather to unload the gun before he would put it in the bag.
And Dillard tries to introduce evidence of all of this.
Right.
What happens?
So the judge says that they're not going to enter. The jury never hears that.
The jury never hears that.
Because
Why?
the judge says it doesn't matter.
It doesn't matter. And this is really important. We've talked about jury instructions being a legal issue as distinct from factual. The other broad category, there's two kind of broad categories of kinds of legal issues that a defendant can raise on appeal after a conviction. One is jury instructions. The other is the admission of evidence, right? Because a judge will not admit evidence because, as Ms. Wall says, because the judge says it's not relevant. Evidence is only admissible if it's relevant to the jury's consideration of one of the legal issues in the case. So if the judge determines, as this judge did based on the instructions, that knowledge isn't required, then any evidence about a lack of knowledge is meaningless. And it would only confuse the jury or bring into the jury's deliberations stuff that wasn't relevant. So the judge, that's what a judge does, is it goes with the instruction, and you're in for a penny, in for a pound. And if the judge decides, rightly or wrongly, that knowledge is not an element, then you're going to exclude evidence about lack of knowledge, and you're not going to require the prosecution to put in evidence of knowledge, and you're going to tell the jury, the prosecution did not, ladies and gentlemen of the jury, you may convict the defendant if you find that he simply possessed this weapon. You need not find that he knew the weapon was loaded, period. Right? Of course, if that law is wrong, then it was wrong to exclude the evidence, and the jury instruction was wrong. If it was right, then it was right to exclude the evidence, and the jury instruction was right. So admission of evidence is going to be a big part, and if you are a party, if you're representing a defendant, you're going to want to try to introduce the evidence. You do what we call making a proffer. Your Honor, I know you've excluded the evidence, but this is the evidence we would introduce if you would be right and let us do it. But you're wrong, so we can't. But we are preserving our record, and therefore that lets the appellate court know what the evidence would have consisted of. Yeah, it's Clemens.
What's to stop, like let's say I'm the defense attorney, what's to stop me from putting my client on the stand and just asking questions that would lead him to
What's to stop you? What's to stop Ms. Clemens? Several things, but what's one thing? I'm sorry? Hands. Show me hands. Yeah. I beg your pardon? No, because then the question's in and the cat's out of the bag. Can it?
I'm going off TV here, but wouldn't the judge stop you?
How would the judge stop you? What happened? What's the first thing that happens when she says, Mr. Dillard, did you know the gun was loaded? What's the next word that's going to be heard in that in that courtroom.
Objection.
Objection, Your Honor. Right? The prosecution's going to object, and Dillard's never going to get the chance to answer because the court is going to say objection sustained.
So what if I don't ask that specific question, but my client throws it in there? Personally, but I didn't ask it.
You're going to be a very good lawyer, Ms. Clemens. Well, the judge, presumably, as it seems like that's what Dillard's going to say, the prosecution may try to stop it. But if he blurts it out and gets it into the air, then the judge will give what we know as a curative instruction. Ladies and gentlemen, jury, the defendant has said, blah, blah, blah. You should disregard that. It is not relevant to the issues you will have to consider.
I feel like that's what I'd want to do, though, because whether the judge says that or not.
So you want to basically be an underhanded, slimy defense lawyer. Now, if you get a reputation for doing that, I can guarantee you the prosecutors in your jurisdiction, let's say you're a defense lawyer, prosecutors do this as well, get in stuff they're not supposed to get in by hook or by crook. If you get a reputation for that, other lawyers will prepare accordingly. Your opposing lawyers will be ready for you, know what tricks you're going to play, and make sure that they are on high alert for that kind of shenanigans. So I would not advise it. At the extremes, another way in which judges make sure this doesn't happen is contempt. You know, you can be, if the judge believes you have purposely tried to evade a ruling in order to prejudice a case, you can be held in contempt. And frankly, at the extremes, again, would be an extreme case, you should be held in contempt. Got to stop there. We're at the time. So I will see. We didn't finish, obviously, Dillard. So we will resume with Dillard next week. And on the 27th, on Monday, we only have 2 cases anyway, so we'll have plenty of time to finish.